All right, Vashawn, do you know you're taking your meds? Do you know I was listening to a clip? I think it was I can't remember the talk show host name, but 50 Cent was on there. And you know what the question was? If you could only listen to one song for the rest of your life, and he said, you don't have to listen to it every day, but if you were going to listen to a song, this would be the only song you can listen to for the rest of your life. 50 Cent came back with an answer right away. And you know what it was? Sade, Cherish the Day. Okay, can I just tell you, I think Sade is so talented. She just comes out, no shoes on, her guitar, and it's just.
Keep on the first row. You gotta sit there.
Good morning, how's it going?
Good.
Hey, Denny.
Got the day right.
Hey, it's Friday. Friday Eve. See, you're like,
I gotta check my calendar.
yeah. All right, everyone have a seat. I am going to call the docket. When I call the docket, you need to stand and let me know you are here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Clinton Dixon, Freddie Ariano, Jeffrey Guerrero, Robert Avalos, Clinton Dixon, Fernando Jimenez, Felipe Reyes, custody. DeJeanette Havana, DeJeanette Miller Havana.
She's present with counsel, sorry, Your Honor.
Thank you. Harold Adams Rowley. Hello. Adrian Daniel Morales, David Ford, custody. Daniel Berlanga, I saw you, thank you. Mario Garza. Alex Russell Bacon. Thank you. Eduardo Hernandez, Paul Garay. Custody, Tammy Franks. Thank you. Orlando Medellin, custody, David Wayne Huff. Thank you. Isaac Valle. Omar Herrera. Eduardo Hernandez, custody, Humberto Alara, thank you. Randall Mobb, Anthony Moran, Shaina Gonzalez.
Electronically monitored, Judge.
All right. Shaina Gonzalez. Shaina Gonzalez. Justina Salcedo, custody, Fernando Trujillo. Fernando Santos Trujillo. I think he's in federal custody. Lazarus Carrillo, custody. Marco Marino Vasquez, custody. Millard Cummings. Millard Durrell Cummings. Camillus Galvan. Leslie O'Bannon. Andre Moody. Christian Reyna, Fabian Rodriguez, Vanessa Rubio, Adis Hernandez Rivas, Brandon Bowman, Felix Acuna, custody. Is there anyone whose name was not called? All right, what's your name on the back row here? All right, thank you.
Mosqueda.
Thank you. All right, Yaya, can you make sure you pull those two files? It's Summer Mosqueda and Duluth, thank you. All right, everyone, these are the rules of this court. Follow these rules. To the audience members, we have inmates on the docket, so they're going to be brought out. Here are the rules with regards to inmates. This is not jail visitation. If you want to visit somebody who's in custody, you need to do it through the proper channels, and in this courtroom is not the proper channel. If you have a seat, please. If you try to communicate with the inmate. If the inmate communicates with you, you're going to be excused from this courtroom. There's no need to talk to the deputy and say there was a misunderstanding. Once they tap you on the shoulder, you are to leave this courtroom, and you will not be brought back in this courtroom unless you are here as a witness. Does everyone understand? Here are the other rules. If you don't see your attorney here, you have the court's permission to step outside and call them on the phone. We are recessing exactly at noon. If your attorney comes running in here at 12:05 and you want to get things done because you have somewhere else you need to be, not the court fault. We're here at 9 a.m. We're ready to go. You will be brought back in the afternoon. Does not matter. Does not matter if your attorney says they need to be in another county because they're going to be here in the afternoon. All right. Everyone, please confer. Oh, and people in the gallery, if you don't see your attorney, you can step outside and call them.
Have a good day, Judge.
You too. Have a good one. It's going to be a great day. It's Friday Eve. It's Friday Eve. It has to be a great day.
Yes.
Have a good one. All right. Thank you.
You have a question, Luz? A question? She's gonna check. Just wait, sir.
All right. Deputy Lawrence. Oh, you guys are already on it. I love that. All right.
I think she's.
Oh, could I find, did you pull the file?
Oh, yeah.
All right. Thank you.
And I did put that order inside your purple folder, or I did, yeah.
Okay. Well, everything in the folder has already been signed. All
Oh.
right. Thank you. All right. Mr. Deleuze, if you could come forward, please. Hello, why are you here today? Oh, it's set for the 19th. All right. Is there anything else you need? All right, you're excused.
Well, I have one question for you.
Sure.
It said something about me being able to work. Is that still allowed?
Yes, the order that was agreed to by both parties, it has already been signed.
My lawyer hasn't said anything about being able to.
All right, you'll have to call him, but everything has already been signed that was agreed to. All right, all right, you're welcome. And Ashley, Deleuze, that was your case, correct? Could you do the court a favor? Could you email the defense attorney and let him know his client was here? All right, thank you so much. Thank you.
So, he and I are like,
Oh, and Rick,
Isaac. Yes, right.
if you all can review this. All right, who is here on Isaac Joel Valles?
Morning, Your Honor.
Good morning.
How are you?
All right, where's he?
He is right there.
Let me find him on the docket. Hello. So on this case, we have a couple of cases that are awaiting indictment.
Yes.
So where are we on discovery?
Um,
And are you on all the
we're,
cases?
we're missing a dash cam, so it's not extensive.
Okay.
But what we want to do is see about a drug court referral.
Mhm.
I think it'd benefit from that.
All right. So with regards to the drug court referrals,
Mm-hmm.
I received an email from them.
Oh,
They're at capacity,
what does that mean?
that they don't have any room because they don't have enough personnel to add more people. So
Does that mean it's shut down or do we wait?
oh, no, it's not shut down. It's just,
No, I mean
Yes.
for new admissions.
oh, there will be a waiting list.
What do you recommend we do?
Well, he has to be on probation to go to felony drug court anyway. Let me ask you this. If you're drug tested, what would the results be? And you need to be honest because we're not on the record. You're not under oath. So it's not going to be held against you because you're not under oath, right? So I'm trying to figure out what way to best help you. And what I can tell you in this court, normally, if there's some type of plea bargain agreement, and I think it's appropriate, my goal is for people to be rehabilitated when they're on probation. So back to my question.
5:30.
All right, and what for? And what else?
Okay.
All right. So do you live at home with anybody or are you by yourself?
Sure.
All right. So one, don't use drugs in your parents' house, okay? Don't smell like marijuana in your parents' house because your parents love you, right? So what I want you to do for me, and hopefully you'll start doing it for yourself, I want you to do some sober support meetings. That will go a long way in making me see that you're on the right track, all right? What I can tell you is they have lifetime recovery, but there's an issue with funding. So
Oh, another problem.
yes, so he'd have to pay for that. But I learned about a new place that maybe you want to look into.
Well, what's the name of that, Judge?
It's called SOBA.
Sofa?
Yeah, SOBA.
Soba.
Yes. And
Probably sobriety something.
let me see what they just call it SOBA, Texas Drug Rehab Detox and Addiction Recovery.
Texas
So of
Rehab,
course, it's
okay.
on a ranch. But you may want to look in it. They do have some testimonials, but you know how that is. But they do have addiction services there. They do have inpatient there. Let me give you the number that appears on this. It's 210-529-8410.
Okay.
And I will give you this, but I don't have an extra copy of it.
I don't, is it like a handbook or something? No, this is enough. We're okay.
Okay.
We'll get on their website.
All right. So make sure that you do sober support meetings, all right? And for you, because you came to court, you're going to be positive, and you knew you were coming to court, that means that you have a major problem. So I want you to do daily sober support meetings. They're located throughout San Antonio, throughout Texas. They're available all hours of the day.
You're talking about NA.
Well, yes, but they call them sober support meetings now, but NA. So do one a day. Now, if you feel you need to do two a day, three a day, then do that. But I'm trying to make sure that you get clean and sober, all right? So starting today, do a sober support meeting, listen to people, talk things out, because sometimes it helps when you see people who are in the same predicament that you're in, or either you see someone who was where you were and now they're in a better place, okay? All right, so we have the body cam or dash cam.
Dash cam.
All right, so State, if you can make sure they get the dash cam.
Yes, Judge.
All right, is there anything else?
No, can we get a date?
All right, if I can have 30 days for discovery, please. All right, June 9th,
6/9?
yes.
Well, thank you, Judge, as always.
Sure, and I'll still do a referral to felony drug court. They won't be able to move on anything unless you're on probation. And also, they'll probably put you on a waiting list, but at least you'll be closer to the top of the waiting list.
Well, let's hope NA starts to kick into, well, daily, what did you call it?
Daily sober support meetings. All right, so make sure you do those, all right? And thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you'll be excused.
Thank you, Judge.
You're welcome. Have a good one. And Norma, do a referral for felony drug court. Who's here in Summer, Muscata? Oh, just have a seat. We're waiting for your attorney. Oh, that one, we're just waiting for the attorney.
Oh, no, that's Rudy's.
Who is here on Havana Miller? All right. If she'll come forward. All right. Who is is this a special prosecutor on this? All right. State, did you make an offer?
Yes.
And how old are you? All right, Miss Ferguson, set this for 3 weeks for a plea deadline date, please. All right. June 5th, on that date, you need to let the court know whether or not you're accepting the state's offer. You've reached an agreement. If you have not reached an agreement, your next court date is going to be a jury trial date. Do you understand? All right, thank you for dressing it appropriately for court. Just have a seat and your attorney will bring you a reset form. Once you sign the reset, you're excused. All right, and has the acknowledgement of discovery been completed?
Yes, it was turned in at the last setting.
All right, thank you. All right, thank you.
It's what you gave to Rick. I don't have any objection to what the court wants to do, but that was just a trial case, so
Okay.
I guess I would
Ah, okay.
propose that he'd be getting credit while he's in there, but on our status conference for the restitution, I anticipate that everything should be
Okay.
resolved that day.
All right, thank you. Yes.
These cases here on bottles. This one is set for jury trial on nine,
Okay.
June 10th.
Mhm.
And he's coming back on June 9th, so do you want him to come back before Thursday, or-
Yes, because June 9th, they say they may work something out, and if they're gonna work it out, it needs to be done on that day.
Okay, so this one is the referral only for this case, not for this.
Just 1 second. You can put them as a referral for all of them.
Okay,
Mhm.
okay, go do.
All right, thank you.
Bye.
Oh, no problem.
Yeah, no, I'm filling it out, just wanted to make sure the date. No. No, no.
Thank you. See you. Bye-bye. Bye, Chair.
Mhm. Thank you, Vashon. We try to do it.
I can vouch. Okay, perfect. He's in jail for it. He's on. Yes. Yes.
LaShawn, I think I'm about to start taking allergy medicine at night because I try to take it every day at the same time. It's causing me, it's causing me to be drowsy. Because I can't take anything. Even if I take daytime medicine, I'm still sleepy. So we shall see if I can switch it up.
You're not allowed to talk to them, just stay on this side. We're gonna sit right there. No, I'm not a second, no, ma'am.
Yes.
Yes.
I'm so sorry.
Thank you.
In preparation for the last chance. We about to continue to run this mechanism. This was what I think the team would manage to do. So what we want to offer is that. I saw that thing. I was like, I don't know, it's just, I haven't had a chance to read that. I saw there's like, you know, there's right there. I think we go hard. Yeah, I'll get it. I'll give it to you. Like once. I'm gonna just be honest, but it's, you want to talk to her again?
Hello, thank you. Tammy Franks. Hello, how are you doing this morning?
Fine.
All right. So who is the prosecutor on this case? All right, thank you. So is all the discovery completed
Yes, sir.
and an offer tender?
Yes, sir.
All right, thanks, Dave. All right, how old are you? All right, so what I'm gonna do is I'm gonna set this in 3 weeks, and in 3 weeks' time, you'll need to let the court know whether you've reached an agreement with the state. If an agreement has not been reached, your next court date is gonna be a jury trial setting, you understand? And counsel, if it's gonna be a jury trial setting, if you all can already discuss whether she wants a bench trial or a jury trial.
Yes, Judge.
All right, I need a 3-week reset. Yes. All right, June 5th, okay? And what I can tell you, if you decide to proceed with a bench trial, if you come to me, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. So if you come to me for a bench trial, I'm just going to listen to the evidence and make a decision based upon what I hear, all right? All right, so we'll be back on June 5th. On that date, you'll need to let me know whether or not you've reached an agreement with the state, okay? All right, and thank you for dressing appropriately for court. Have a great rest of your day. All right, so if you'll let her sign the reset form, then she's excused.
Yes, Judge.
All right, thank you. Oh, thank you. And counsel, if you could sign the acknowledgement of discovery before you leave.
Yes, Judge.
Yes, sir.
All right, who is here on Vanessa Rubio? So is your client in custody?
She's in the hospital.
All right, but I mean, technically, is she in custody?
Yes.
All right, so do you know what the hospital status is?
No, I just got an email saying that she was in the hospital. They did not disclose any other details.
All right, so this is what I'm going to do. I'll reset this as well for June 5th.
Okay.
And then if you can give me some update of when they think she'll be released from the hospital, then we can recall it on a different day.
Okay.
All right, thank you.
Thank you, Judge. Maybe excuse.
Yes, Ms. Ferguson Rubio is recalled for June 5th. Vashawn Rubio is recalled for June 5th. Marco Marino Vasquez. We need an interpreter. Are they here?
Yes, yes, Judge, I called them already. They said they were on their way.
All right, so once the interpreter comes, you can give me the file.
Yes. Thanks.
Hello,
Good outcome on the trial.
I'm sorry, what?
Good outcome on the trial.
Ah,
Motion to suppress granted.
yeah.
I kind of thought so. We took it under consideration, then looked at it again, and he goes, no, it's just.
It's the first stop got thrown out, so then the second one by necessity had to. That's a weird one. I've never seen that before.
Well, good luck. I love when I see attorneys, fighting for their clients. So that's always great.
Yeah. Every now and then, we gotta take the ones when we can get them.
Okay. All right, who's here on Marco Antonio Marino Vasquez? All right, thank you.
Morning, Judge.
Good morning. So counsel, do you have all discovery now?
I do. We've gone through it. The state had recently given me some new discovery. I've gone through it with my client. He also provided videos, which I've gone through that I don't think my client needs to see, but they are potential Brady that we can use later if we need. So I think we need a trial date, Judge.
Yes, we do. Does he want a jury trial or a bench trial?
Jury trial.
With the jury.
All right. All right. How long do y'all expect this trial to last?
I would say at least a week.
I would think so.
There's a few videos. in it.
Oh, okay.
I mean, it has security surveillance that might be a little bit longer than the normal.
All right. If you all will speak with Ms. Ferguson on a jury trial date and then come back to me with the date that you all agreed upon.
Thanks.
Do you have any questions, sir?
And we did,
Thank you.
We've sort of narrowed it down, Judge.
Judge, I mean, just looking at our schedule, the only dates that I see that if it's one of this year
Everyone, please whisper.
would be December, the Monday's the 8th, but December 9th is a Tuesday. That's, I mean, because everything else we sort of has,
It's booked.
well, yes, Your Honor, unless you want to get it to January, then that's
Yeah, right.
entirely up to you.
All right, this is what we'll do then. Mr. Marino, in this court, we're in trial every week. I don't like for people to have to wait for their jury trial. But the state can only try one case at a time. And I try to make sure that trials are placed on the docket as quickly as possible. The earliest date that we can give you is December 9th. Now, if for some reason there is an opening that opens up sooner, we can let your attorney know and we can have you brought over sooner. Do you have any objections to the December 9th date?
Well, for me, the sooner the better.
All right, let's go on the record. Court is calling 2023 CR 4371B State versus Marco Antonio Marino Vasquez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
For the
David A.
defense?
Garcia, attorney for Marco Moreno Vasquez.
And are you Mr. Marino Vasquez?
Yes.
All right, if I can have the interpreter, if you can raise your right hand. Do you solemnly swear or affirm do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. So, as I was stating off the record, Mr. Vasquez, we try to get cases set in jury trial as quickly as possible. If I had 20 prosecutors in this courtroom, we could still only do one jury trial a week because I have other cases that I have to attend to as well. I know your case has been on the docket since July of 2024. There have been several issues that are outside. Oh, excuse me, just one second. Are you the first attorney on this case?
I am, Judge, but there have been a lot of discoveries that have come in over time. And I think that's one of the reasons why things have been delayed.
And yeah, just for the discovery purposes, the CPS information just became relevant or actually given notice to us and actually just developed in probably the last couple months or so. And then he does have a co-defendant that was set before him that ended up fleeing, and he's pending sentencing. So that may have complicated issues. also.
Okay,
So that might be something.
all right, because I'm looking at the time that he's been on the docket, and he's actually been on the docket for what I consider to be a long time, but now that that has cleared that up.
Right. And then I think one other thing was it came in as
Tampering.
tampering
Mhm.
as opposed to the murder.
And and it's still listed.
Right, it's still listed as tampering, and that was one of the issues that I had to contend with my client, because he kept arguing that he's only charged with tampering. And I was like, no, there's also a murder.
Well, and actually, I believe, my understanding is that it's a 3-count indictment. It's murder and tampering, and also, I believe, deadly conduct or something like that.
Yes, and then there's a burglary of a habitation. Well, no, there's a discharging of a firearm at a habitation. So, sir, you actually have 3 counts in your indictment. You have a murder count, you have a discharging of a firearm into a habitation. And then
The tampering.
and a tampering.
May I speak?
Sure.
Es lo que no entiendo yo eso, porque desde los primeros 3 meses que me llegó el indictment, tenía yo el caso de muerte. Después desapareció y me pusieron temporary evidence por más de 16.
All right.
That's what I don't understand. In the last 3 months, they told me that they gave me the indictment and it showed the murder, but then it was the tampering.
All right, so let me just explain something to you. When they do an indictment, the court receives one, and the court receives the original that's signed by the foreman of the grand jury. So this is your indictment, and there are 3 counts in it. Now, sometimes what will end up happening, for some reason, when a case is indicted, instead of the higher level felony being listed first, they list the lower felony. And then people will think, oh, I'm just charged with a 3rd-degree felony tampering with evidence. But there are other counts in it. So whenever you see something, when they're bringing you over from the jail and what you're charged with, they don't list all 3 counts that are in your indictment. They'll just list one offense. And so in your case, that's why I always get confused when I see you, because in your case, on the court's docket sheet, it'll just say tampering with evidence. That's why I was looking at both of them. How can a tampering with an evidence case take 5 days or a week? But then when I go back and I remember and I look at your indictment, and 1 count, you're charged with murder, and another count, you're charged with discharging a firearm at a habitation, which means a place that's occupied and somebody's living. And then the 3rd one is tampering with the evidence. So when they indicted you, they just took 1 general case, and they, under that 1 case number, they put all 3 counts. If they wanted to, they could have said, you know what, we're going to charge him in 3 separate cases. You have 3 separate cause numbers. 1 cause number will be the murder case. 1 cause number will be the discharging at a habitation, and the other one will be tampering with evidence. But they just decided to put it all in 1 indictment. Do you understand?
Sí.
Yes,
Ahora, le pido por favor.
I ask you, please.
Por eso ya tengo más de 1 año y medio diciéndole al abogado que quiero ir a juicio.
It's been more than a year and a half that I've been telling my attorney that I want to go to trial.
Porque lo que por eso quiero ir a juicio, para que el jurado me escuche y también la juez me escuche, porque aquí no me dejan hablar cuando yo vengo.
That's why I want to go to trial, in order for the judge to listen to me, the jury to listen to me, because when I come here, nobody allows me to speak.
Y luego, para lo que me están acusando de muerte, que me están acusando que le disparé a una habitación, y lo otro, por eso quiero que me enseñen las pruebas de que tengo, porque yo sé que yo tengo mi mente limpia, que yo no hice nada. Quiero que me enseñen.
And then they're telling me that, there's the case of murder and then the discharge of a firearm. So what I want is for, to be able to see all the proof and everything that they have.
All right, so let me explain something to you. Sometimes the length of time that it takes you to go to trial is outside your attorney's control. The way I say we can't do two cases at the same time for jury trial. We came close one time. We had a jury deliberating and started another trial. But your attorney can't be in two places at the same time. And I guarantee you, Mr. Garcia, I know him. He's never been to my house for dinner, so I don't know him that way. But what I can tell you is, I know for a fact that he's been in a jury trial since your case was pending. And if he's in a jury trial somewhere else, he can't be in a jury trial here because nobody can be in two places at the same time. And then when we're in a jury trial, we can't have your trial. So then your case will get pushed back to another day. So the fact that this is your setting day is not your attorney's fault. It's not my fault. It's not the state's fault. It's just that your case is not the only case on his docket, on the state's docket, and my docket. If your case were the only case that was pending in all of the cases that I have, and I think I have over 1,000 or something, we would try your case right now. Today, I would bring a jury in, but that's not what we have. Now, with regards to your viewing the evidence, I've been a defense attorney, I've been a prosecutor. What I can tell you is sometimes people, when they're charged with a case, they don't look at their evidence objectively. They want something and they want their attorney to tell them something different than what they're seeing. Your attorney can show you the evidence, you look at it, and then you make an informed decision on whether or not you want to go to trial or whether or not you want to reach an agreement with the state. I will tell you what I tell everyone here. I've had people come to me before bench trials. I found some people not guilty. I found some people guilty. Whatever evidence is presented to me, this is a murder case. For me, I would listen to the evidence and I'll base my decision on the evidence that presented to me. I'm not going to say, oh, the state didn't prove their case, but this is a murder case. Let me find somebody guilty. For me, it's a murder case. Did the state prove their case beyond a reasonable doubt? Even on a murder case, if they didn't prove their case beyond a reasonable doubt, I'm going to find you not guilty. If they prove it beyond a reasonable doubt, I'm going to find you guilty. Do you understand?
Yes.
Now, if you want a bench trial, I can get you in here sooner. But in order for you to be entitled to have a bench trial, the state has agreed to waive the jury and you have to agree to waive the jury. So if you want a bench trial, then we can do it sooner. If you want a jury trial, the earliest I can have you in here is that December 9th date. If something falls through, the state can call your attorney, the coordinator will call your attorney and say, we have an earlier date open. Do you understand?
Yo no le estoy echando la culpa a ellos de que el juicio, ¿cómo se llama? Que se está tardando nada de eso.
I'm not
Simplemente
blaming them that the trial is taking long or anything.
yo no me estoy guiando a lo que ellos me están diciendo, que me dicen que una fecha y luego otra y otra y yo estoy esperando.
I'm basing myself on what they're telling me. You know, they give me one date, they give me another day, they give me another day. You know what I mean?
The reason why is because when you are given a jury trial date, if there's a case that is older than yours, that is on the docket as well, then that case will go first. In your case, you had a co-defendant. The co-defendant decided to enter into a plea. So once he or she entered into a plea, then your case became next. Your number ends in the letter B. So the person whose number ends in the letter A goes before you.
Okay,
Y otra, no es porque no
Thank you,
quiera
maybe
ir
excuse.
nada, sino simplemente que en más de 27 meses no me lo he visto 2 veces por aquí nomás.
well, and the thing is, not that I don't like him or anything, but in the 27 months, I've only seen him like twice.
All right, so here's the thing. Let me just tell you another thing. Sometimes defendants want to see their attorneys. They would love to see them on a daily basis because I know this is an extremely important case to you, right? But
Uh-huh.
some attorneys, if they don't have any new information to give you, their whole thing is, why am I seeing you? I don't have any information to give you. I'm going to show up and say, hey, we're waiting on this discovery. I don't have it yet. Now, I will tell you, when I was a defense attorney and I was starting out, and this is how you get burned out, I would see, if I had a client in jail, I would see them once a week. I would take the via bus, go to the jail, and I would see my clients on Saturdays and Sundays. And I would come and I would tell them, hey, I'm just letting you know that I'm still working on your case. I'm still waiting on this. Because sometimes the only visitor that your client will have is their attorney. Now, I would do that. I didn't have to do that. And your attorney doesn't have to do that. If they don't have any new information to impart to you, there really is no reason for them to see you. Because at the end of the day, in the words of John Wayne, we're not here to make friends. We're just here to do a job. Right?
Uh-huh.
So that's where we are. Now you're saying you haven't seen something.
See something?
He said he hadn't seen what the state has against him.
Nomás me enseñaron un video que tiene en contra mía, que según estuve presente, y es lo que he visto yo nomás. De
The
100,
only thing I've seen is a video that they showed me where I was supposed to be there. That's all I've seen.
de 100 videos que trae el investigador, nomás me han enseñado
So
uno.
let me ask you this.
The 100 videos that the investigator has, they only showed me once.
All right, so here's the thing. My question is, have you seen the police report?
Ah, no me enseñó nada.
They have not shown me anything.
All right, so Mr. Garcia, I understand what's going on. But if you could just grab the state's file and let him read the police report.
I'll do it again, Judge. I've done it in court
I know
many
you have.
times. My investigator spent countless, a lot of hours showing him tons of video, reading him all of the reports. My investigator speaks Spanish perfectly, and that's why we have that done so that there's no problem. It's much harder here in the court, but I'll go through it again.
All right, so they're gonna go over the police reports with you again. It's gonna be whatever is in the state's file, and your attorney will look at that. And after looking at that, if you change your mind about anything, just let the court know. But your court date is gonna be December 9th.
Thank you, Judge.
Gracias.
Muchas gracias.
Yes, thank you very much.
De nada. That's all I know, really.
Oh, here's a copy of the-
Yo tengo uno, yo tengo como tres.
May I approach on the floor, Lieutenant?
Yes, just give me one moment. All right, if you can have them pull the file. And is the co-defendant out here?
No, it's downstairs, we're trying to. He couldn't come up.
Okay. Oh, it's a PSI?
Yes.
Okay,
He is sentencing judge, but I believe he's going to be a witness for the state of Texas.
all right.
So this is why I need to.
If you can
He's aware of it.
talk to the state and make sure that he's going to be a witness, you need me to sign.
I just spoke to Mr. Garrett.
Thank you so much. My pleasure. I spoke with Mr. Garcia and I told him that if he needs help, just give us a call. Oh,
My
your client.
client is.
All right, so here's the
Okay.
thing. With regards to your client, he's reading a couple of things, so I don't know, he may decide to change his mind. So if you could come back by 11:30, are you able to come back?
Yeah.
All right. She's gonna come back at 11:30 for her client, Deputy Laura, so you don't have to bring him up now. Okay, thank you.
Thanks. Thank you, Judge.
You're welcome. Who is here on Fernando Trujillo? What is his status?
He's still in federal custody, Judge. We just came back to check on that and
Oh, I've already reset that. I still don't know why it's on the docket. It's been reset for August 25th because my understanding is that his federal case is reset for August 18th.
fantastic.
All right,
I'll
thank you.
make sure the firm updates the calendar.
All right, thank you.
What date again was that, Judge?
It is August 25th, and let me
August
just
25th.
check the calendar, just 1 second. Yeah, August 25th.
Thank you very much, Judge.
You're welcome. Yes. Sure. Norma Trujillo shouldn't be on the docket. Well, we reset that for August 25th. I think I already put that in the system. Lieutenant David Huff. All right, if you'll come forward. Probation, this is an application. All right, counsel, you on this side. Court is calling 2025 CR 003649, State versus David Wayne Huff. Can I have parties announce?
Matthew, finished for David Huff, Your Honor, ready.
And are you Mr. Huff?
Yes, ma'am.
Counsel, have you received all discovery?
I have, Your Honor.
Did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Mr. Huff, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
All right. Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram, within 1,000 feet of a playground, and that makes it a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Huff, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. The state recommends community supervision. They will take in consideration 2025 PF 06925. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plea?
No contest.
State any evidence.
State offers exhibit 1 and attachments, Judge.
We've reviewed those, Your Honor. We have no objections.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we waive PSI today.
Anything you wish to say on behalf of your client?
Your Honor, my client is motivated. He's accepted responsibility today. He's asking the court to follow this plea bargain. We would ask that you sentence him accordingly and follow our recommendations to the court as well.
All right, so how long have you been using?
About 10 years.
All right, why did you start? What happened in your life?
My mom, my dad, and my stepdad was killed in the car wreck.
I'm sorry to hear that.
Kind of messed me up, but
So are you, if you were tested today, what would the results be? All right, positive for what? And what else? All right, so here's the thing, where you're starting at now today, it's the court's hope that this probation, you'll improve and you'll get clean and sober and you stay clean and sober. So do you have any support system?
yes, ma'am. They want me to go to treatment.
Right, so I mean, do you have, where are you, who do you still with?
I got my own house. I stay in Castleberg Road. But,
Okay, so do you live by yourself?
Yes, ma'am.
Do you have any children?
No, I got 2 kids, but they live in West Texas.
And what are their ages?
My son's 24 and my daughter's 18.
All right, do you have any grandchildren?
No, yeah.
Okay, are you working at all?
ma'am.
What do you do?
I work for, right now I work for People Ready.
I'm sorry, what?
For People Ready as an electrician.
Okay.
So.
All right. This is what the court will do. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's to be no contact with Veronica Renee, Renee Trevino. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month until further notice. There's going to be 200 hours of community service restitution. 120 sober meetings in 120 days. A referral to felony drug court. TAP evaluation. Out of custody. Follow TAP recommendations. Probation, is there anything else he needs? And I'm sorry, taking consideration 2025 PF 06925.
Judge, may I approach?
Yes. Is there anything else you need from the court in order to be successful?
No, ma'am, I appreciate it.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right. In this court, to be successful on probation, communication is key. So if there's an issue, talk to your probation officer. If you feel as though they're not addressing it, you can always come back to court. And nobody can help you, and we can't help you with your drug addiction if you don't want to help yourself. Now, I've ordered that you have a TAP evaluation out of custody. They're going to give you a date for that. If you miss that date, what's going to end up happening is a motion to revoke is going to be filed. You're going to be taken into custody. Either you'll make bond or you won't make bond, and I'll hear that motion to revoke. So if you need to get an appointment booklet, get an appointment booklet and put your dates down. You understand? And when you leave here today, other than following their instructions, you need to go to a sober support meeting. Those are the NA meetings, so you can get your life back on track. Because if you continue to use, only two things going to happen. Either you're going to end up in prison, right? And you're going to lose everything. You're going to lose your house. You're going to lose even more time with your children. Or either somebody's going to have to come down and identify your body. You understand? All right, good luck to you.
Thank you. Your Honor. May we
Thank
excuse-
you. Yes. Just have him remain in custody to speak with probation. Yes.
Mark Herrera on the docket.
Mhm.
With the state, we have an offer, but they want to find out what the restitution is.
Okay, I mean, I'll do that. Just, yeah, it's over here. Yeah, I'm going in order. I just have to put this in the system. All right, Omar Herrera. Omar Herrera. Where's your attorney? All righty. Who is here on Roberto Avalos Jr.? And probation, there's no application. Court is calling 2024 CR 012312, State versus Roberto Avalos Jr. Can I have the parties announce?
Megan Galloway for the state.
Jimmy Callahan defense.
All right, and are you Mr. Roberto Avalos Jr.?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Avalos, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Avalos, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand by entering into this agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Avalos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Oh, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers states one in attachments.
No objection.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Fair County District Clerk's records reflect 44 days. I think that might be slightly inaccurate because I believe he's been under arrest either in this county or in other county since August the 22nd, 2023.
All right, if you will make sure to verify that with the clerk. What I can tell you, sir, if there is any time that you've been in custody while this case has been open, you'll receive credit for that. All right, the court will find you guilty, sentence you to 6 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money run concurrent. There's to be no contact with Dora, D-O-R-A, Marie, M-A-R-I-E, Bravo. Is there anything else with regards to sentencing?
No, Your Honor, but for, I believe that some required under rules of ethics, the pending case is complaining, or rather the person you said he must have no contact with. I think that case is still pending in your court.
All right. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome. All right. Omar Herrera.
Morning, Judge.
Good morning. Yes. Oh. So on this case, where are we on discovery?
Judge, I think we've done all the discovery and there are just a couple of issues that we're just trying to figure out,
Okay,
and that's restitution on each case. The state's gonna need a little time just to reach out to the complainants.
all right. How much time do you need, state?
30 days.
All right, Ms. Ferguson, I need a plea deadline date for 30 days. All right, June 12th is your plea deadline date. Is there anything else?
No, Your Honor.
All right, thank you for dressing appropriate for court. Just have a seat. Once you sign the reset form, you'll be excused.
Thank you, Your Honor.
Thank you. Deputy, Laura. Where are we on discovery?
I think probably we have, what we need, I would imagine, Judge. There's two issues I'd like to address with the court. One is, he was remanded without bond. My client, actually came to my office, I don't know, maybe about a month before the trial setting. He doesn't have a phone. He did leave me an email address, I think, or my office got an email address. I tried to send him an email, but it didn't go through. He didn't ever receive a letter or notice in the mail about the trial date. And so he really didn't have any notice of the setting.
All right,
And so I was
so
gonna see if we could get a bond set or get the bond reinstated.
you'd have to,
Yeah,
File-
I'm not evading, I'm
No, no.
on my way.
you'd have to file a motion, and the soonest we'll be able to hear it is Monday.
Okay.
All right.
Okay, Judge. And I guess the other issue is that, I think we need to get a trial date. That if he's not gonna be able to get out.
All right, so what we'll do is we'll recall it on, Norma, recall this for Monday, the 19th. That'll be to hear your bond issue, okay?
Judge, is it possible that, is there any other day that, is it start the Monday? Or is Monday the day?
You want the 20th, the 22nd?
The 22nd would probably be better
All right,
if it's possible.
sure. Ms. Ferguson, recall this for May 22nd to hear the bond issue.
So the same.
All right, and then if you want a jury trial, you need to decide if you want a jury trial or bench.
Trial.
All right, if you want a bench trial, talk to your attorney. And then if you'll confer with the state, we can do a bench trial quickly. So just talk to the state on a date. This is a state jail, I'm assuming.
Yes.
So it shouldn't take that long.
No.
It should be done in a day.
Absolutely.
You're welcome. So just let us know when you would like that.
All right, thank you,
No,
Judge.
they're gonna be requesting a bench trial. Thank you. Have a good day.
God bless.
Oh, thank you. God bless you too. Yes. Mhm. Okay.
January, she's on, and on the other one, they. The other piece, so.
All right. Well, let-
I have a third box on them, I'll show it, but the once he verifies the bonds are good.
All right.
Make that ever.
Thank you. Lazarus Carrillo.
He wants to go back. He is not.
Oh, no, we're gonna do that right now. Where is he? Oh, no, have him come back out. He's gonna talk to his attorney. That's what he wanted. That's what's gonna happen. Is this what you need to speak with me?
Your Honor, this and one other
Oh, in the back?
matter. Yes, sir.
All right. Everyone, just give me 5 minutes.
So I talked to AAA, bail bonds. They're saying they didn't get off the bond, but I guess there were some early problems like back in January
Okay.
where they were behind.
All right, so he should be free to go then.
Okay.
All right, thanks.
Thanks. Sir.
You're welcome. All right, who's here on Lazarus Carrillo?
Daniel de la Garza and Marcus.
Are they're in the hallway. Can you peep out in the hallway and tell them, come on down? Yes. No, yes, for the bond hearing. And then if they can do whatever they want on the bench trial. I mean, if they wanted, yes. Oh, I'm sure the state will agree. Yes, and if you all want a bench trial,
Judge, the state is just gonna tell you maybe, I guess. So I don't know if that's a yes or a no.
I'm sure it'll be a yes. Just figure out what date you all want your bench trial. It should be a day.
Okay.
All right, they're gonna bring your guy back from the back. My understanding is that the bondsman is on his bond. All right, so where is Lazarus
Right here.
He's
Korea? Come down, please.
Yes, sir.
All right.
Have a good day.
Okay, my understanding that this came from another court. It's been on the docket since August 2024. So this is what we're gonna do. Y'all are not seeking the death penalty, is that correct?
Correct, Your Honor.
All right. So I'm going to give you all, do you have all of the discovery? Do you know if you have all discovery?
That's what I think we're gonna have to go over, and that's why we're asking for 45 days, because of the two places, and just make sure that she's got it and that we've gotten it from her.
All right, Miss Ferguson, recall this. I'm gonna recall this for 60 days. Say at that time, you'll need to be prepared to tender an offer to the defense.
Yes, Your Honor.
All right. All right,
What's it in?
July 14th.
Okay. that's
On that
perfect.
date, what's going to end up happening in this court, I like for things to move, for progress to be made. So on July 14th, your counsel is going to have all the discovery. The state is going to tender an offer. After that, you're going to get a 30-day reset, and that's going to be your plea deadline date. And on that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date is going to be a jury trial. And for jury trials, the court does not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right. Is there anything else?
Not from the state, Your Honor.
Nor the defense. Right?
All right, thank you. Then the deputies will take him back.
Thank you, Judge.
You're welcome.
Or. No, no, actually, it's gonna be that. Yeah.
And Norma, did you call down a translator, an interpreter, I should say? All right, thank you.
That's for docket management purposes. Freddie, Ariana, and Fernando Jimenez are please.
All right, thank you. All right, who's here on Summer Mascata? Hello, come forward. All right. So where are we on discovery?
Judge, I'm not certain, to be honest with you. As I expressed to the court yesterday, I was unaware that this case had been indicted or was set this week until I received an email from the court on Monday stating that the time that the court was having docket had changed. So as a result, I haven't had an opportunity to fully review all of the discovery. I hadn't talked to my client in over a year, Judge, so I haven't had an opportunity to discuss this case with her recently. I know I was here yesterday and there was some concern about me being able to reach her. We did get a hold of her. I do have new contact information for her, so that shouldn't be an issue. So
No,
we
she
were,
came in late yesterday, so she made it after, this is a full service court, after we used our contacts in court to reach out to her. All right, Ms. Ferguson, I need a 30-day reset on this date. State you need to be prepared to tender an offer.
Yes, Your Honor.
All right, June 12th,
great. Thank you, Judge. May we be excused?
after she signs the reset form.
Thank you, Judge.
All right, thank you. Who is here on Christian Reyna? Christian Escobar Reyna? Is that the reason why I have this file?
It's a miscommunication, Rich. The cover had said that he was at the hospital, he was not.
Okay. All right, who's here on ATIS? Oh, we're waiting for the interpreter. Deputy Laura,
Yes, Rich.
we have a new book that is recent by McFadden,
Which one is that?
The Tenant.
Okay.
So it sounds like from reading the cover, it sounds like it's going to be similar to The Colony. I don't know. Mario Garza. All right, thank you. Deputy Laura, it appears that he's listening to his attorney now. All right, counsel, where are we on discovery? Have you received it?
Yes, Your Honor, I have.
And that's okay. State, were you able to tender an offer?
Yes, Judge.
All right, sir, how old are you?
54.
All right, Ms. Ferguson, if you'll set this in 2 weeks for a plea deadline date, please. All right, we'll be back on May 29th. At that time, you need to let the court know whether or not you've reached an agreement. If you have not reached an agreement by that time, your next court date will be a jury trial date. Thank you for addressing appropriate for court. Once you sign the reset form, you're excused.
Thank you.
Thank you, man.
All right, good seeing you. All right, just give me a moment, please.
He's spoken about something else. No, not yet. I'll let him know that you're. See here?
He is not here right now, but he was here, and he wanted to speak with you about a case.
It shouldn't be long.
Yeah.
Right now, coming down on. Told you. No, don't do that shit. Don't say the owl.
It's in front of the animal.
So it's a county purchase.
I like it.
Those are the laws. Finally said.
Baby and Rodriguez.
What are you doing? Yes, where's the defendant? Is your email address?
Oh. Jim Rayner. Front row, maybe. I don't care. Remember, she's the one that had the Oh, yes. You're okay. Yeah.
All right, who's here on Andre Moody?
I do too.
Yes.
We're just gonna set it for a contested judge.
All right. Uh, All right, State, how long do you think it'd take for this contested? It's a GPS fob. Just 1 second. Hello? Yeah, everything is fine. I had to answer that for call for another judge. Is it people like? All right, so the allegations in the motion, there's only one allegation. So what do y'all need, 10 days?
Fine with that, Judge.
All right, Ms. Ferguson, I need a 10-day reset for a contested hearing. All right, May 29th.
Yes, Judge. Thank you.
Probation on Moody, May 29th, contested hearing. And Jason and yes. All right, who is here on Eduardo Hernandez III? And after that, it will be Brandon Bowman. And probation, this is an application for deferred. Court is calling 2025 CR 004-104. State versus Eduardo Hernandez III. Can I have parties announced?
Rick Pena for the state of Texas.
Doug Campbell for Mr. Hernandez.
All right, if y'all cannot talk behind the court reporter while we're on the record. And are you, Mr. Hernandez?
Yes.
Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Mr. Hernandez, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hernandez, did you review the court's admonishments with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with injury to a child or elderly or disabled person, bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? You need to speak up.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Excuse me, miss. If you cannot whisper, then you need to stop talking. We're on the record. All right. Are you a U.S. citizen?
Yes.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2025 CR 003443. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea?
Yes, ma'am.
Defense is that the plea?
It is.
State is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 80 hours of community service restitution, a MIC evaluation, follow the recommendations from MIC, a TAP evaluation, follow all recommendations in anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, this time state offers into evidence State Exhibit 1 with all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. And state, have you spoken to the complainant?
Yes, we have, Your Honor.
All right. And then the complainant's name is listed with the last name of Garza in the police reports. But in the plea bargain agreement, you put it as Hernandez.
Judge, it's his stepmother. I'm not opposed to it. If the court needs to make a change. We're not.
All right.
You're right, I'm sorry. It-
Well, actually, they have two. They have one that's Hernandez and one that's Garza. And they have two completely different birth dates. So I'm assuming it's no contact with both. Because one is listed as January, one is listed as October
I think it's.
in the stipulations.
It is Garza. It should be Garza with the January 10th, 1959.
Okay,
I think the other one might be a typo.
all right. Love typo, gotta love typos. All right, thank you, State. You may be excused. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Mr. Hernandez is going to be homeless because of this incident. While he wants to take responsibility and get this behind him, he's not going to have a job. He's not going to have any money. He would like some assistance in finding a house if that's possible to. Any of the services the court might have available to it. He also would like to have it probated, defined, and he'd like to do his evaluations while out in the world.
All right, so why didn't you clean up your mess in the kitchen? Yeah, that's what it says. It said they told you to clean up your mess in the kitchen. You became upset and said something bad was going to happen and you will not like it. That's what you told the complainant. So how old are you?
I am 39.
Why are you living with your parents anyway?
I got kicked out of my other parents' house. And I lost my job too.
All right, so why did the other parent kick you out of their house?
They got upset. They're arguing about something about a bowl. That's my boss. It's just
Something about what?
a bowl, a cereal bowl.
Mhm.
And then Marianne just got an argument.
All right, so here's the thing. You're an adult. You shouldn't be going from parents' house to parents' house. And I'm going to tell you what I tell everybody who is an adult or living with somebody else. If you want to keep a dirty kitchen, you can keep a dirty kitchen. But guess what? It needs to be your dirty kitchen. So whether you're an adult or not, whether you're 21 or 60, if you're living under somebody else's roof, you need to follow their rules. You understand? They're asking for a MIC evaluation. Is there any prior mental health issues?
That's my nephew.
I'm sorry?
He has physical deformity, Judge. He can't hear out of his left ear.
Oh, okay.
So you might have to speak up a little.
All right. They're asking for mental health evaluation? Have you ever had any mental health diagnosis?
No.
All right. So do you have any children?
No.
This is what the court is going to do. 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, taking consideration 2025 CR 003443, $1,500 fine, probated, affirmative finding of family violence. There's to be no contact with the complainant and no contact with the complainant's address, which is on Larkia, Larkia Lane. So don't be on that street, you understand?
Yes, ma'am.
Proof of employment within 30 days. There's to be no employment as a home healthcare provider or with minors. Field visits 1 time per month until further notice. 100 hours of community service restitution. TAP evaluation, that can be out of custody. Follow recommendations. And they're asking for a MIC evaluation. I'll go ahead and do one. MIC evaluation out of custody. And I'm gonna order anger management classes and a life skills course. The court will give him 50 hours credit for completion of the anger management class towards his community service restitution, and another 50 hours credit once the life skills course is completed. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
I don't know.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did
Yes,
you
ma'am.
understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, in order to be successful at probation, communication is key. If you have an issue with probation, let the probation officer know. If there's anything you need help with, let them know. If you feel they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge. Might be excused.
Yes, you may be excused. Thank you. Who's here? I'm Brandon Bowman. Yes.
I'm actually put him up there for some.
I'm sorry, what?
Brought him up, brought this case for you for some edification.
Okay.
That's a big word.
I love the word.
Okay, so
Edification.
he has an MTO on judge that is saying that it's a third degree felony, and I looked through the court's file. And in all my years, I've never seen a third degree felony done on a state jail
Paperwork.
paperwork.
Mhm. That has been known to happen in this court.
I didn't know.
My guess is that we might have reduced it and maybe the clerk, and it was not properly titled, maybe.
All right.
It,
let me
it,
see.
and the reason
I
I
haven't
brought
looked at
that
the
up
file
is
yet.
because, Bama told me no, but I'm on for state jail, and that's why I looked through the court file.
Let
So I
me
wanted
just
to
see.
see what was going on.
Oh, it wouldn't be on here because this was, let's see.
The judgment says third degree, paperwork says.
But yeah, but that would be entered by somebody that
Right.
might have just looked at the title of it. 'Cause I imagine if there's state jail paperwork, it should be reduced or I can look at the stibs and know if for sure,
Okay,
Judge.
I'll let you guys do that. All right, thank you. Harold Adams Raleigh. Who's the attorney on Raleigh?
Yes, Your Honor. Sorry.
He was talking to John.
All right.
I'm spinning.
Oh, are you all ready or no?
Your Honor, we need 2 weeks to allow Mr. Riley to get his affairs together, and we have an offer. We haven't rejected it. I got a power appointed from the bench.
Yes.
And I there's an offer in there and we're discussing it and we're close to maybe coming to a resolution. He needs to make sure he gets square with some family members before he takes the deal.
All right, on this case, set it for a contested in 2 weeks. I'm sorry, it's not for a contested. This is just a regular case.
Yeah,
Do a plea deadline date and you say May 29th.
yes.
All right, May 29th. Once you sign the reset form, you're excused.
Okay, yes, ma'am.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Yeah, I'm spinning a lot of plates today, which is good.
Judge, I did look, I actually, did the plea, and it was, the language was changed. And it does say less than a gram.
All right, so then what we'll do is, I'll send an email to Barbara. She'll, y'all can change the judgment. On this, the judgment should reflect that it's a state jail felony. All right. Who's here on Christian Reyna?
That would be the.
Has he shown up to court?
Yes. It's been in your judge.
Okay. Yes.
So I've gone through everything with Marco Moreno Vasquez. He has no further questions. Just want to let the court know.
All righty, Mr. If you can come down, please. If they can give me his file, please. And I'm sorry, what's your client's name again?
Marco Moreno Vasquez.
Can I see the file on Marco Moreno Vasquez, please? All right, so you had a chance to see everything? Yes. All right, so we'll bring you back for your jury trial on December 9th. As I said, if there's an opening that's sooner, the state will reach out to your defense counsel and we'll bring you back. Any other questions?
No, that's all.
No, that's it. All right, thank you. Thanks,
you, Judge.
counsel. Thank you. You're welcome.
Maybe it's good.
Yes. Who's here on Adis Hernandez Rivas? Ah, okay, we'll wait for them.
And it's Monica Guerrero.
So, well, on this case,
So yeah, it's gonna get,
reset.
needs to be reset till at least after, so the week after, maybe December 9th. Probably be the 16th or the 15th.
Norma, on this case, move it to December 16th. It's on Adis Hernandez Rivas. Yes.
Jimenez.
All right, and Robert Porter, on Bowen, just let me know whenever you're ready. All right, thank you. Are the parties ready on Freddie Ariano? Court is calling 2024 CR 010818 and 2024 CR 010820, State versus Freddie Ariano. Can I have parties announced?
Ashley Jones for the state.
Melissa Christian for the defendant.
And are you the defendant in this case?
Yes, ma'am.
Counsel, in each of the cause number, have you received all discovery? Did you review it with your client?
I have, yes.
Court will find that the state is in compliance with discovery. And each of the cause numbers, did you review the true bill of indictment, sir, with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment in each cause number?
I do, Judge.
State, are you proceeding on the indictment as presented in the cause number ending in 18?
We are not, Your Honor. The state is proceeding only on count 2 of that indictment, and we will waive the remaining counts.
No objections.
And are you proceeding on the indictment as presented in the cause number ending in 20?
We are not, Your Honor. The state, again, will proceed only on count 2, but paragraph D of that indictment.
No objections.
All right, in each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
In the cause number ending in 18, you're charged with aggravated kidnapping, bodily injury, and cause number ending in 20, you're charged with aggravated sexual assault. Each of those cause numbers, the range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has.
In each of the cause numbers, do you believe your client has a rational as well as a factual understanding of the charges against him?
I do so believe, Judge.
In each cause number, do you believe your client is currently competent and was legally sane at the time of the offense?
Yes, Your Honor, and just for the record, he was assessed psychologically and came back competent.
And sir, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement
Yes, Your Honor.
with your attorney and did you understand it?
Yes, Your Honor.
In each cause number, the state is proceeding on count 2. And in the cause number ending in 20, they're proceeding on paragraph D of count 2. Punishment is to be assessed at 10 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. There are no applications. The case will run concurrently. There's an affirmative finding of family violence. There's to be Chapter 62 compliance and no contact with the complainant. Did you understand that to be the plea in each of the cause numbers?
Yes, Your Honor.
Defense, is that the plea?
That is, Judge.
State, is that the plea?
Yes, Your Honor.
In each of the cause numbers, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge, motions have been filed, but the answer to your question is no.
And cause number 2024 CR 010818, how do you plead to count 2?
No contest.
And cause number 2024 CR 010820, how do you plead to count 2, paragraph D?
No contest.
State any evidence in each of those cause numbers.
State offers State's Exhibit 1 and all attachments for both cause numbers.
We have no objection in either cause.
In each cause numbers, did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. In each of the cause numbers, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right, state, is there a reason the court should follow this agreement?
Yes, Your Honor. We have spoken with the complainant in depth. She is an adult and this is the outcome that she wants.
All right, then cause number of 2024 CR 010818, the court is finding you guilty. There's an affirmative finding. There is to be a $1,500 fine. This will run concurrent with 2024 CR 10820. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's to be no contact with minors. And there's 10 years in the prison. Credit for any time served. Is there anything else with regards to sentencing in that cause number?
Your Honor, was this cause number 20?
No, this is 10818.
And. No, Your Honor.
Okay. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Next, the court is proceeding with 10820. The court is finding you guilty. There's an affirmative finding and also an affirmative finding of family violence, Chapter 62 compliance. There's a $1,500 fine, 10 years in the prison. This will run concurrent with 2024 CR 10818. There's to be no contact with the complainant. And there's to be no contact with minors. Is there anything else with regards to sentencing in that cause number?
Not from the state, Your Honor.
Nothing from the defense.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in that cause number? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You're receiving the 10 years because the complainant was satisfied with your receiving 10 years. If you would have went to a jury trial and the jury were to find you guilty, they probably would have given you life. You understand?
Mhm.
You're not supposed to treat people that you claim to love this way. You understand?
Yes, Your Honor.
All right, my understanding, there's going to be a victim impact. The
Yes.
deputy's going to take you over to that side. You're Christian Reyna. Are you ready to proceed?
Yes, Your Honor.
Court is calling 2021 CR 9092W State versus Christian Reyna. Can I have parties announced?
Megan Galloway for the state.
Got my.
And are you Christian Reyna?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand that?
Yes, ma'am.
Are you the same Christian Escobar Reyna who was placed on deferred adjudication in cause number 2021 CR 9092W for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams?
I am, Your Honor.
All right, state.
A violation of condition number 4. In Bexar County, Texas, the defendant Christian Escobar Reyna did then and there fail to report to the supervision officer as directed for the months of September of 2024 and January and February of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
Violation of condition number 4 on or about the 4th day of March 2025 in Bexar County, Texas. The defendant Christian Escobar Reyna did then and there fail to report as directed by the court for a compliance hearing in the 187th District Court in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
And then violation of condition number 4 in Bexar County, Texas, the defendant Christian Escobar Reyna did then and there fail to report to the supervision officer as directed for the months of March of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
We waive and abandon the remainders, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violations 4, 4, and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
I understand, Your Honor.
Knowing that, do you still wish to plead true to violations 4, 4, and 4?
Yes, ma'am.
Court will find 4, 4, and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking for revocation and that the defendant be sentenced to 2 years in the prison based on his lack of actively participating in his deferred adjudication.
All right, and what are you requesting?
And Your Honor, I was also with that for a plea of truth, it would be TIC a new number 1.
And that's correct, Your Honor. We have TIC cause number 2025 PF 15283.
And what is that offense?
It's a possession less than a gram.
All right.
And for that reason, my client is asking for lifetime recovery, Your Honor, as an alternative to TBC. He would like to address the court if the court would allow.
Sure. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Christian Reyna.
All right, so this is not your first motion to revoke. Your previous motion to revoke was for not reporting. And now we're back here for not reporting. And then the court tried to see what was going on with you. I set it for a compliance hearing and you still did not show. The only thing you've accomplished on this probation is picking up a new number 1. What would you like to discuss?
First of all, I want to say that I have 2 kids.
No, don't bring your children into this because you had 2 children when you were placed on probation. You had children when you were not doing what you're supposed to be doing on probation. So do not use your children to play sympathy and say, oh, my children really need me. You were not a good parent to your children while you were using drugs. So you haven't been in their lives. Don't pretend like you've been seeing them. And if they're in school, that you've been keeping up with their schoolwork and going over homework with them and going to any plays or events or extracurricular activities they've had, because you have not been doing that. Now you want to come to me and you're using your children as a reason why I should continue you. So let's not start there. Let's start by taking responsibility for our own actions.
Yes, ma'am.
So what would you like to say?
I have everything going for me out there. I have a supporting family that loves me and wants me there. And I just have this problem that it's my drug use. And that's all really that's my only problem. I'm a good person.
I'm trying to do what I'm supposed to do.
All you had to do was pick up the phone and call probation. I tell everybody who has drug issues to reach out to your probation. If you think you're going to use, reach out to your sober support person. If you can't get in touch with anybody, you can still come back to court. And I tried to have you get back on track by setting it for a compliance hearing, and you still didn't show. So basically, what you want to do, it appears to the court, you're not trying to be clean and sober because you're not reaching out to call anyone. You're acting as though you're not on probation. And there, I can't help you. I can't help you anymore because you don't want help.
I understand.
All right. Court is going to find you guilty. The court is going to revoke, taking into consideration 2025 PF 15283. The state is requesting that your sentence be 2 years in the prison. I would sentence you to 4, but I'm going to go along with the state and sentence you to 2 years in the prison. I'll request the therapeutic community. And if you're truly serious about your condition, the therapeutic community will most likely accept you, but you'll have to request it.
Yes, ma'am.
And I'll give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
I did, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
We can go off the record. Here's the thing. I'm gonna reach out my hand to you again. When you're released from prison, if you can't find a place to stay to help you with your sobriety, if I'm still here, you can come back here. I will pick up the phone, get a placement for you. Do you understand?
I understand.
Only 2 things can happen with the path you're on. Either you're going to end up in prison or jail for a majority of your life, or either somebody's going to be identifying your body. You understand?
I do.
All right. Good luck to you. Okay.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
And he does get all his back time.
Yeah, he'll get credit for any time that he's been in custody.
Thank you, Judge.
You're welcome. I got no more files. Who's here on Umberto Lara? Oh, yes, come up. All right, what is happening on this case? Where are we on discovery?
Judge, we have received discovery. We're currently reviewing it.
Okay.
I also have conferred with our client, and he has some things he'd like for me to pass on to the state. So we're gathering that information for them as well.
All right, and state on this case, was an offer able to be tendered?
Yes, sir.
Ms. Ferguson, if I can have a 30-day reset for a plea deadline date. All right, you're going to come back on June 12th. At that time, you need to let the court know whether or not you reached an agreement with the state. If you have not reached an agreement, your next court date is going to be a jury trial setting.
Sure.
All right, just have a seat and they will give you a reset form. Once you sign that, you're excused. Thank you. Good seeing you. Berlinga. All right, on this case, were you all able to receive the discovery?
Yes, Your Honor, we have defense is satisfied, and I think both sides have turned over what we have.
All right, Ms. Ferguson, I need a jury trial date. So what is this, 3 days?
Probably, yes, Ron.
Tops.
All right, 3-day jury trial date for family violence. I'm sorry, okay, June 3rd.
Yes, ma'am.
All right, once you sign the reset form, you're excused. Your jury trial will be June 3rd.
Thank you.
Thank you. And counsel, if you'll make sure, if you all have not done so, to do the acknowledgement of discovery.
Yes, ma'am.
All right, thank you.
I've signed several.
Okay. What page is he on? All right, thank you. Anthony Lee Moran. Is he in custody?
I'm sorry, who was that, Judge?
Morin, Morin. Sorry, Maureen.
Yes, he's downstairs.
All right, he's going to be recalled back for Monday. Maureen. Let him know his attorney said that they did not receive notice. Fabian Rodriguez.
He's in custody, Judge. There's an unindicted felony pending. It's failure to stop and render aid. I spoke to Jason Garahan. He's going to get with grand jury, find out what's going on with that case. We anticipate the court will schedule this one for a contested hearing, perhaps as early as next week, if you'll do it. That way, we can be in front of you with all of the cases instead of just one.
State, are you in agreement to setting this in 10 days for a contested, or do you need more time?
Well, Judge,
like I told Mr. Montgomery, we would be waiting probably the new number one to go in on technical. So, I mean, it is what it is because it won't resolve all of his cases, but but it can be if that's what the defense would like.
I just feel like I need to explore that option to make sure that we don't leave anything.
All right, Ms. Ferguson, if you'll call this back in 10 days, then.
Also, Judge, it's a motion to enter adjudication of guilt and he's remanded without bond. If the court would set up, I'll ask you to do that.
All right, if you all will file a motion and then I'll hear it. All right, so we're going to come back on May 29th for a contested hearing.
Thank you.
All right, thank you. Who is here? I'm Brandon Bauman. All right, court is calling 2023 CR 6541 State versus Brandon Bowman. Could I have parties announced for the record for the state? And is there a motion to correct the motion to revoke?
Yes, Your Honor, we ask the court to amend the motion to revoke to reflect that the defendant is on deferred for the state felony offense of possession of controlled substance. UG1 less than a gram.
Any objection?
No objection.
All right, Mr. Bowman, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Brandon Bowman who was placed on deferred adjudication in 2023 CR 6541 for the offense of possession of a controlled substance penalty one less than 1 gram on May 28, 2024 for a period of 4 years? Is that you?
Yes.
State?
Violation of condition number 1 on or about the 21st day of March 2025 in Bexar County, Texas. The defendant Brandon Bowman committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violation of condition number 1 on or about the 21st day of March 2025 in Bexar County, Texas. The defendant Brandon Bowman committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of conditions 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes, ma'am.
Court will find violation 1 and 1 true. Is there a proposed agreement?
There is, Your Honor, it is to adjudicate the defendant guilty, revoke his community supervision, sentence him to 8 months in the state jail facility, and for the court to take into consideration cause numbers 2025.
Just 1 second. 2025?
Yes, 2025 CC 004565 and 2025 DC 004679.
All right. Is that the agreement, counsel?
It is, Your Honor.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement. The court will find you guilty, revoke, sentence you to 8 months in the state jail facility, give you credit for any time served, take in consideration 2025 CC 004565, 2025 CC 004679. Is there, and the court will order a therapeutic community. Is there anything else with regards to sentencing? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
You're gonna have to do better in your life because we're off the record. 1 or 2 things going to end up happening. Either you're going to end up in jail or in prison for all these drug charges that you keep picking up, or either somebody's going to have to identify your body. Those are the only two choices. Once you're released from custody, if you can't find a place that can help you with your sobriety and help you get your life in order, if I'm still here, I'll pick up the phone and get you the help you need. You understand?
Yes, ma'am. Thank you.
All right, thank you. Counsel, with regards to all right, this is the last case, then the court is going to take a recess and it's Acuna. Counsel, you're on the side.
Oh, yes, sir.
Oh, no, I haven't called it yet. You're still doing great. All right, court is calling 2023 CR 9998 State versus Felix Acuna. Could I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Dwight Chumley for Mr. Coon.
All right. And are you Mr. Acuna? Did you review the document entitled Motion to Revoke Community Supervision and State's Motion to Supplement Pending Motion to Revoke Probation? With your attorney, did you understand it?
Yes.
Are you the same Felix Xavier Montoya Acuna who was placed on community supervision in 2023 CR 9998 for the offense of driving while intoxicated with a child under 15 on March 28, 2024 for a term of 2 years? Is that you? All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Felix Xavier Montoya Acuna did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, November, and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
Yes, ma'am. True.
State.
Violation of condition number 4 in Bear County, Texas, the defendant Felix Xavier Montoya Acuna did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2025 in violation of condition number 4.
How do you plead to that? True or not true?
We waive and abandon the remainders, Your Honor.
Any objections to the waivers?
No.
Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, sentence you to 2 years in the prison and up to a $500 fine? Knowing that, do you still wish to plead true to 4 and 4?
Yes, ma'am.
Court will find violation of condition 4 and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking that you revoke the defendant's community supervision and sentence him to 2 years in the state jail facility based on the stipulations that he has absconded from probation and the court since going on 10 months.
Your Honor, we have a explanation due. If I might inquire of my client. Your Honor.
Yes, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Yes, Mr. Coon, you're here in front of the judge today and you've been on probation for a little over a year, maybe a year and a half. Can you explain to the judge, you pled true that you did not report on various months in 2024. Can you explain to the judge what your situation was and why that did not happen?
My situation was that I was traveling back and forth from San Marcos to San Antonio. And back and forth, I didn't have time to check in. I know I should have picked up the phone, honest to my heart. I know I should have called at least several times, but I didn't. Between work and back and forth traveling, I mean, transportation to get over there and come back was hard for me and I.
So here's the thing, if he was actually living in San Marcos,
No.
I was gonna clarify for you.
Yes.
I was explaining to the judge, you were living in San Antonio and working in San Marcos, is that correct?
Yes.
And what type of work were you doing there?
I was doing construction.
I don't understand.
I was doing.
Here's the thing, though. I don't understand why you didn't pick up the phone to call probation. I thought his testimony was gonna be, I was in a coma. I just woke up. Or either I had a serious injury. Or either I was kidnapped by strangers and I just found release. What you're giving me is not a good excuse for not reporting. Because in this court, I always tell people if there's an issue, let your probation officer know. All you have to do is pick up the phone and call somebody. You're telling me you should have known, you should have called somebody and you didn't.
I got busy with work, yes, ma'am.
So I don't know what you want me to do.
Yes, I will, if I might ask, you were required to connect on a interlock device for your vehicle, is that correct?
On my vehicle, yes.
And you were able, you did go through the process of doing that, is that correct?
On the homing device.
Okay, and then you had another requirement condition that you met involving the claim report, which you explained to me that you had done. You have records of doing.
On the process of me being on probation, I had completed the education program, the DWI education program. And on the other side, I did complete the DWI in voluntary.
You have proof of that?
The VIP, the impact program, and I also have a certificate for the family parent class.
All right, where's the certificate?
I have it at home. I did not appreciate, I mean, I appreciated that I'm here at court, but I did not know, and I don't have any
Oh,
relatives
did you
here.
ever turn that over to probation that you've completed that?
I sent a message to my probation officer.
All right, probation, do you have proof that he has any of that? All right, is there anything else?
If it makes a difference to you, Judge, I think if you give him a couple of days, he's been in custody, how long now? 60 days?
60 days. I am a trustee too, so yeah, 60 days.
I could maybe fetch that stuff for you.
All right, this is what I'm gonna do. I'm gonna revoke you. I'm gonna sentence you to 2 years in the state jail facility, give you credit for any time served. There's a 2-year license suspension. And I'll order the therapeutic community. Counsel, if you're able to provide the court proof that he has done those things, then the court will reconsider, not revoking him, but reconsider the amount of time.
Thank you.
All right.
Appreciate it.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. All right, we can go off the record. So if your attorney is able to bring documentation to the court that you have actually done those classes, I will reconsider the sentence of 2 years. I'm not going to continue on probation. I don't think you're a good candidate for probation, but I'll consider classes that you've completed. Do you understand?
Okay, bye.
All right, thank you.
Yes.
Yeah.
We'll bring it back.
Give me a
Bring it
phone
back,
number.
bring it back.
Yeah. Who do I call? Okay.
Yes, we'll get it to you.
478
Okay,
81
478.
427. Okay, I'm sorry, 427 64 80.
All right, and Melissa,
Yes,
And
sir.
her name
on
is
your case, if you all have already done all of the paperwork, you can appear by Zoom.
No,